hearing docket. We will call them in the order in which they appear. Let me remind council that each side has a total of 15 minutes for argument, and that applies even if more than one attorney is arguing. The appellant has the right to reserve up to 5 minutes for rebuttal. So when you come to the podium after you've introduced yourself, let us know how many minutes you wish to reserve, and we'll program the clock accordingly. Are there any announcements or introductions? Hearing none, call the first case.
Robert H. Beckham et al. Versus City of Waynesboro, Tennessee.
Good morning.
Morning, Your Honors. Chuck Holliday with the Madison County Bar for the appellants Robert and Ashley Beckham. I'd ask to reserve 3 minutes for rebuttal, please.
3 minutes, yes, sir.
Judge, may I ask a preliminary matter?
Sure.
I heard, I know we're live streaming this, but somebody said something about a high school watching or something?
Well, a high school group had been planned to attend, and unfortunately they had to cancel.
That's fine. I was going to do some initial facts, but I'll skip that. Since
Sure. Okay.
Thank you. May it please the court. This court should reverse the trial court's decision granting summary judgment for 2 reasons. First, swimming in a city pool is not a water sport under the Tennessee Recreational Use Act. And second, alternatively, a city swimming pool is not a premises or land, as that term is used under the Tennessee, or the trust, for abbreviation. The trust, as your honors know, was enacted in 1963, and the purpose of the law was simple: to encourage private landowners to open up their property, large tracts of land, for hunting and fishing. Legal commentators and early cases have supported this conclusion that it was intended to apply to natural, undeveloped, rural areas. This court in Wilkerson versus Altitzer, I'm butchering that, I'm sure, noted in 1992 that the trust is located under Title 70 of the Tennessee Code, Wildlife Resources. And this court said, quote, that the trust is, quote, intended to apply to sportsmen who commonly use the land of another for recreation, such as hunting and fishing. When the law was first passed, it did not even have a list of the types of activities that were to be included under that. It wasn't until the 1987 legislation that those activities were added. The list, which is at TCA 70-7-102, is clearly geared toward the great outdoors. It discusses activities like bird watching, rock climbing, and trap shooting. In the 1999 case of Parent v. State, the Tennessee Supreme Court held that the list was not exclusive and included activities similar to those in the list. And that's why we find ourselves here today. Defendants looking to avoid responsibility for their actions have tried to expand the statute beyond its intended boundaries. A good example of this is a recent case from the United States District Court for the Middle District of Tennessee, Weems versus Omni Hotels. In that case, the plaintiff tripped over a lounge chair while going to check out a hot tub at a hotel. The hotel tried to escape liability in that case by arguing that the trust applied, that the person was engaged in either water sports or sightseeing, and so therefore there was no liability because the hotel would be exempt under the trust. The district court rejected those arguments, noting that the law was geared toward risky activities, it said. It's similar to the Georgia Court of Appeals, in which they noted in a similar case involving a hotel pool that adopting such a liberal construction of the trust would lead to absurd results, like a dance club escaping liability because it involves a recreational activity of dancing.
Counsel, what are we supposed to make then, though, of 77-101-1C, which defines out swimming pools that are located immediately surround a residence? I mean, what what's the purpose of having that carve-out in 101(1)(c) if swimming pools couldn't be within the reach of the broader act?
Well, Your Honor, the 101(c) excludes swimming pools and says they are not subject to, if a swimming pool around someone's residence exists, the trust is not a defense in that type of case. So the issue in this case is that the swimming pool, it says around a, it does not include, under 101, the section you're talking about, does not include improvements erected for recreational purposes that immediately surround the landowner's principal place of residence, including swimming pools. The problem that we have is that another part of the section, which defines landowners, says that landowners includes governmental entities. And so the statute becomes ambiguous because a governmental entity does not normally have a principal place of residence, but they are a landowner nonetheless under the law, and it references swimming pools. And so there's that ambiguity there as to how does a city swimming pool fit into the section when it just talks about a landowner's swimming pool around their principal residence, but a government doesn't have a residence. So this.
Why doesn't that simply suggest that the government or the act is intended to have broader protection for government than private actors? And I've got this carve out. If I'm looking at the statutory provision, if it's near your principal residence, around such residence, and the way the statute is written with the 101(1)(c) carve out, the government gets protection that a private citizen doesn't around their primary residence.
Your Honor, because it's ambiguous, the court, if you look at the legislative history, it's abundantly clear that that's not what was intended. And in fact, it shows that the General Assembly threw in governmental entities under the definition of a landowner, not after vigorous debate on the subject about whether they should be included or excluded, but more to help river outfitters on the Ocoee. The discussion, if you listen to the history there of the tapes from the debates, there was some discussion about river outfitters on the Ocoee needing, because of insurance costs, needing protection. And they said, well, how do we do that? Well, we throw governmental entities in. And so they threw governmental entities. And the discussion actually on the legislative history was that there was concern about giving governmental entities too much immunity. There was a discussion about baseball fields and public swimming pools, and the idea, there was one senator, I believe, who talked about a backstop at a baseball field, and if that killed a child, should the government be immune from that under this? And he had serious concerns, and people agreed with him. And actually the amendment that would have broadened the protections for governmental entities was voted down and was not made part of the bill. So I think if you look at the legislative history and the location of where this was not intended to apply to either residential swimming pools or a concrete city pool that the city of Waynesboro operates.
Isn't there if you look at the list in section 102, and it says water sports, whitewater rafting, canoeing, etc., aren't you supposed to interpret words in a list as being related? And there's nothing in this list about places that are not more rural and adjacent to something. I mean, hunting, fishing, animal riding, that's all. Even water sports, they use associated with it whitewater rafting and canoeing. So are you not supposed to interpret all these in a way that links them together in a sense?
Yes, Your Honor, and I believe, I apologize, I don't have the Latin term memorized. There's a Latin term for that.
You're right.
But I can tell, Your Honor, that I was talking to my children last night, and I said, wooded forests, a man-made concrete swimming pool, jagged cliffs, and dark caves. To quote Sesame Street, one of these things is not like the others. And I asked them, which one of those is not like the others? And they thought for a second, they both said, a swimming pool. There's a 10-year-old and a 13-year-old. The list is clearly geared toward outdoor activities. It doesn't mention basketball. It doesn't mention football. It doesn't mention baseball. It doesn't mention all. And in fact, if we go back to the list that Judge Usman was talking about, that includes barbecue and horseshoe pits and things of that nature. Again, we're talking about more urban or activities not in the great outdoors. And so, yes, Your Honor, I think if you look at that, the problem is the Supreme Court, when they use the word similar activities, opened the door to very creative legal arguments, and that's how we ended up with the hot tub sightseeing defense. Because someone came in and said, well, they were sightseeing when they went to go look at it, or that's a water sport. And so this court is and courts in general are starting to see these types of arguments. I'm aware of another case in which there's an argument being made that because some people were walking across a bridge at a marina, that they apparently are, that landowner is going to be arguing they're immune from the trust because the person was at a marina walking over a bridge to a restaurant. The broadening of this statute beyond those terms has taken on a life of its own in the last few years since that decision. And if this court looks at the title where it's located, Wildlife Resources, looks at the type of activities listed in 102, looks at the previous decisions of this court, the Tennessee Supreme Court, and other courts, most courts have held that it's intended to apply to the great outdoors. And so this court should conclude that a city pool should be considered an improvement erected for recreational purposes that would immediately surround a governmental entity's principal place of residence if it gets to that point. I don't think the court has to get there, though, because it can say under 102, swimming in a city pool. Now, swimming in a lake, we might have a different case before your court, but swimming in a city pool is not an activity excluded by the statute. And for that reason, we'd ask that the court reverse the decision of the trial court granting.
Counsel, on that last point, can you explain why swimming in a lake would be a water sport, but swimming in a pool would not be a water sport?
Your Honor, based on the case law, the idea of water sports, if you look at the Middle District where they talk about risky activities, swimming in a lake or a natural body of water is different than a man-made pool. And in a lake, you have all of the things that can come along with a natural water feature versus, as one court noted, I think it was a Pennsylvania court, with a city pool that's under the control of the city. They can clean it up, they can keep it in good condition, they can do all of these things. Whereas a natural water feature, a waterfall, a river, a lake, you aren't going to police the entire bank of the Ocoee River and make it safe. Thank you.
All right, thank you, Mr. Holliday. We'll hear from you on rebuttal. Good morning.
Good morning, Your Honors. My name is John Burleson. I'm a member of the Jackson-Madison County Bar, and I'm here on behalf of the City of Waynesboro, the appellee in this matter. Your Honor, we would ask that on behalf of the City of Waynesboro that Judge Sockwell's decision to grant summary judgment be granted. The judge went through the appropriate analysis of the Tennessee Recreational Use Statute Trust, if I can use that term, in reaching his decision. We're asking, and we think what the court is compelled to do, is to apply common sense, practical interpretation of the language used by the General Assembly in this legislation. That's how the General Assembly speaks. And I'm going to address this. I think Mr. Holliday, my good friend, professional colleague, is trying to create an ambiguity in the statute that does not exist. The statute is very clear applied to the facts in this situation. If you look at section 70-7-102 and just read the provisions of the statute, a governmental entity is a landowner. Land is defined as the real estate or any structures or buildings or waterways on that real estate. So I don't think there's any dispute from the other side about the meaning of those words. And then we get into the language of, well, does the immunity provided by the statute apply here? To determine that, Number one, the Parent versus State of Tennessee, the Supreme Court told us there's a two-part analysis. Was the party involved in a recreational activity as defined in section 10270-7-102? And then secondly, were there any exceptions applicable under 104 of the statute? That's exactly what Judge Sockwell did. If you look at section 102 of the statute, it clearly applies to the city, it being a landowner. A swimming pool is part of the land. It's a structure on land owned by the city. And then, of course, we're asserting that the recreational activity is water sports. I want to address that very briefly as I can. The Supreme Court addressed this issue earlier in the Parent case, and they noted that this list in the statute is not exclusive or exhaustive based on the language of the statute itself, because the General Assembly said, for such recreational activities as, in other words, this is not an exclusive list. Water sports is one on that list. So, Your Honor, obviously swimming, we will concede that swimming in a swimming pool is not explicitly stated as a recreational activity. But this court has used a dictionary to define even the term residence in section 101 of this statute. And if you use a dictionary, and I've cited it in my brief, a dictionary definition of the term water sports, it includes swimming. Frankly, I don't think you need a dictionary to know that water sports include swimming, but it does. So clearly swimming...
Does it include swimming even when you read this list in the context? It all describes outdoor, rural kind of activities rather than a activity such as a man-made pool.
Well, I think it does, Your Honor, and let me go to section 101 of the statute to give you some, I think, something that supports that. Under 101(1)(c), the exception provision for residences, if there's, as you know, if it's a landowner's principal place of residence, any improvement erected for recreational purpose that is located immediately around such residence shall be excluded from this statute. So the legislature is acknowledging in section 101, subparagraph 1C, that a swimming pool is a vehicle for recreational activity. So I think... Didn't you say that had to do with residences? It does, Your Honor, but I guess the point I'm trying to make is the legislature was making a carve-out for swimming pools that, to me, it's clearly logically inferred that swimming pools are intended to be covered by the statute. They recognize that a swimming pool is an area for recreational activity, and they've carved it out for principal residences.
So if it's at a principal residence, it's not covered under this?
Yes, sir, that's right.
So if a swimming pool is at a state park, that's not a principal residence?
Exactly. A government doesn't have a principal place of residence. And this court has actually used a dictionary to define what residence means, and I'm going blank. I think it was in the I think some Kague case. I'm going blank right now, but I know there's a case, and it's in my brief, where this court has looked to define what a residence means under trust, and it talks about a dwelling or where somebody dwells and lives. Clearly, a government can't do that.
So a swimming pool, in your mind, in your advocacy here, is no different than a lake out in the middle of somebody's property?
That's right, Your Honor. When you swim, there's risk. When you use a diving board, there's risk.
Yeah, that's another question, I think, in this lawsuit. But it seems I'm having a little trouble with this, because it seems to me pools are different at residences. Either the government or regs or your insurance company usually makes you put a fence around it. At a park or other place, there's usually a lifeguard. And that's different than a lake out in the middle of the back 40 of mine.
It could be. I don't dispute that, but I think we have to look at what the language used by the legislature is. And had they intended to exclude swimming pools, they easily could have done it. They could have done it easily in section 101(1)(c) by just deleting the words, the landowner's principal place of residence. That would have excluded swimming pools from the statute. It was real simple if they wanted to do it, if they intended to do it, but they didn't. And so to me, that's a clear implication that the statute is intended to cover risk at a swimming pool. They made a carve out for the principal place of residence. I don't know why, but that's their prerogative. And to me, they left it in for governmental entities or other private property that's not around the principal place of residence. And Your Honors, in terms of determination of recreational activity, this court has decided that, for example, bicycling on a paved trail is covered by this statute. This court has determined that, actually that was the Supreme Court. This court has determined that attending a concert is an activity that is covered under this statute. So I don't think the position that is raised by the city here is extreme at all. I think it's in line with the language of the statute. And the statute clearly states that if a landowner or if a person, a landowner does not owe a duty of care to someone who has owned land for involvement in a recreational activity such as water sport, which is exactly what we have here. And so without the city owing a duty of care to the plaintiff cannot make a case for a tort claim against the city, and the judge appropriately granted summary judgment. And Your Honor, Your Honors, we've addressed this, but I guess I want to make sure that at least I get a chance to reinforce my points on section 101(1)(c) regarding the carve-out for principal place of residence. As I've said earlier, I think that implies clearly from a logical point of view that that is a carve-out, and if it's carve-out, the implication is swimming pools are included as a water sport. It was the McCaig case where the appellate court defined a residence as a place where one actually lives, a house or a dwelling. So clearly, this subparagraph C does not apply to a governmental entity. A governmental entity doesn't have a residence, doesn't live in that place, doesn't
Counsel,
apply.
Under your argument, does that mean that sitting in a hot tub is a water sport?
I think that's a distinguishable case, Your Honor. Number one, they weren't in the hot tub. They were on their way to the hot tub and they tripped and fell. But
somebody gets in the hot tub. Are they engaged in a water sport sitting in a hot tub?
I guess there's an argument that they were, and I know that in that middle district, that was a federal court case, the Weems case, and the court seemed to focus on the risk that was involved in the activity, and they determined that the hot tub was not the level of risk intended by this statute. I respectfully disagree with the district court on that, because the way I read this statute and the case law that interprets it, there's no measurement of the risk of the activity, because the statute covers bird watching. I mean, maybe there's risk there, I don't know, but some of the activities are very low risk. So yes, I think arguably being in a hot tub could be considered a water sport, although I think swimming has more risk. If you want to use the federal court judge's analysis, I think swimming has more risk than a hot tub. But yet, to answer your question, yes, I think arguably it could be covered by this statute and a property owner could be immune.
Working through that list of the carve-outs here, saunas. Is being in a sauna a water sport? I mean, where does the line end here in terms of water sports? What's the activity you're engaged in a sauna?
Well, I'm not sure that I don't know that I can say that being in a sauna would be a water sport. You know, swimming, what we have here, swimming clearly is a water sport. And Your Honor is kind of trying to figure out where that line is. In a sauna, you're not in water, you're in steam, at least if I understand a sauna correctly. I think that would be a weak argument to make that that's a water sport. So, Your Honors, and I know that Mr. Holliday and the Beckhams are relying on legislative history, but I don't think that's appropriate here. This statute is not ambiguous, and the language is clear. It speaks for itself. When you, and as courts have noted, and this court's aware, legislative history, there's all kinds of comments that can be made in legislative history that are not instructive and can't even be have political motivations to be there. And so there's no reason to explore that in this case because there's no ambiguity, and even if you did, the legislative history here doesn't lead to the conclusion that the plaintiff wants or the appellant wants.
What do we do with the fact that this statute is under the title named Wildlife Resources? Isn't that a clear indication of something other than a swimming pool at a facility?
Actually, it's not, Your Honor, and I've addressed that in my brief. The only time you're to look at that is if there's lack of clarity or ambiguity in the statute, and we argue there's not here. There's no need. That's like going to the legislative history or looking at the title. You look at what the legislature said in the statute and how they spoke. That's how the General Assembly speaks. They use common everyday language that people other than lawyers would read this and clearly understand it. But lawyers, we have our job to do. Mr. Holliday's doing his job. I think that the legislature did their job in passing the statute and using plain language, recreational activity, water sports, residence, principal place of residence. Those aren't ambiguous. We know what they mean. I understand if the appellants don't like the meaning of the statute, but the statute says what it says, and we're asking you to enforce it. And we're asking you, we think Judge Sockwell went through an appropriate analysis. He made the appropriate decision, and we ask that you uphold his ruling.
All right, thank you.
Thank you.
Mr. Burleson. Mr. Holliday. What do you say about the residential swimming pool carve-out?
The residential swimming pool carve-out, how it applies to this case? Your Honor, I believe it shows that there is ambiguity in the statute because a landowner is defined under the law as a person, or it could be a company, or a governmental entity. There's nothing that sets out, you would expect that the legislature might have said something along those lines because they lumped it in together. A landowner includes governmental entities, and then the section that talks about a residential pool just says landowners. So if a governmental entity is a landowner, then they're subject to that interpretation, and we know that they don't normally have principal places of residence. So I think that does create an ambiguity in the statute. I think the Tennessee Supreme Court's decision in Parent using the word similar suggests there's ambiguity in that list. They left open the door and said, look, this is not an exhaustive list. If something is similar to that, that leads to the idea of we're going to need to interpret whether swimming in a public swimming pool is going to be within that list or not. There's necessarily some ambiguity there. And I feel like, Mr. Burleson is a worthy opponent and a great lawyer, but I feel like he wants the court, they don't want this court to look at the legislative history. It feels like the Wizard of Oz where they're like, don't look behind the curtain. Because in this case, the legislative history was very clear. They considered an amendment to the law that would have broadened the exclusions, and it was considered and it was voted down in the committee, and then one of the other similar bills. There was a gentleman talking about his bill, and he withdrew it from the committee, and there's no history that's ever been presented. So the history in this case, sure, you can say that sometimes people make statements in a legislative context in order to put...
Counsel, can I ask a quick question
Yes,
here in terms of how would your argument apply to a privately owned campsite pool? So if I've got a pool on one of these, not a government pool, but a privately owned pool in a rural area. So I've got a rural area pool, but it's a pool. It's not a lake. It's not a river. How would your argument apply to that type of pool?
That gets us really into, Your Honor, the very splitting of hairs, because Technically, the campground is, if it's a company campground, then they don't have a principal place of residence, but they are a landowner under the statute. And so again, I think we're left with, is swimming in a swimming pool, we go back to 102, is that a water sport under that section? And that gets us to where we would say, no, a campground pool is not swimming in a water sport under the act. Thank you.
All right, thank you, Mr. Holliday and Mr. Burleson, for your arguments. We will take the case under advisement. Call the next case, please.